Good morning, everyone. Happy Monday. I am Carol Williams with Williams Immigration, and we are here for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. The first thing I want to talk to you all about, of which much digital ink has been spilled this past week, is the question, is adjustment of status dead? And so my short answer is to you all, no, it's not. Is it slightly more complicated? Absolutely. Is it dead? Absolutely not. So if you haven't heard, a new memo was released about a weekish ago. No, maybe 2 weeks ago now. Anyway, it was released the Friday of Memorial Day weekend. So, it's the standard Friday surprise. And that memo essentially described adjustment of status, which is the last application so that you can get your green card if you are here in the United States. It essentially described adjustment of status, that application, as an extraordinary benefit and something that was not meant to be the norm, and explained that the norm was meant to be that people applied in their home country at the U.S. consulate through a process which is called consular processing. Consular processing is essentially the same as an adjustment of status application, but it's just done outside of the U.S. in someone's home country at the U.S. consulate. So the memo then went on to say that because adjustment of status is in fact discretionary, that they don't really, they're not really buying into this whole everybody gets to adjust situation. So they have, through that memo, instructed local office, field office adjudicators who perform the interviews of adjustment of status and green card applicants to assess each application under the totality of the circumstances. And so looking at all of the favorable and perhaps not so favorable aspects and factors involved in someone's application and their general immigration background. And to approve where the applicant's equities, meaning their good factors, sort of outweigh their not so good factors in an application. I can tell you, as someone who used to work at USCIS at headquarters, it takes a while for guidance from headquarters to make its way down to each individual officer in each individual local office. So what we are seeing is officers and different offices, different local offices in different cities and states handling this new memo a little bit differently. Does that surprise me? Absolutely not. This memo is brand spanking new. So, it's going to take some time if this memo actually remains in place. If it does, it will take some time for the officers to get clear guidance from headquarters, and then for all the local offices to actually implement and do any sort of training that they need to do on the guidance. But one thing is clear. One thing is super clear. We need to ensure that folks that are applying for adjustment of status, we need to look at their positive and not so positive factors. We need to look at the totality of the circumstances when it comes to their applications. And we need to make a decision, whether adjustment of status or consular processing is perhaps the best option for them. Now, are these decisions made every day for every adjustment that we file? Yes, they are. So from that perspective, it's not terribly different from what we do for our clients every single day. We just now have this one memo in place. It's one more thing that we'll have to add. Will we probably have another Friday surprise? And will there probably be something else that changes how we strategize and look at adjustment of status? Probably. I would be surprised if there wasn't. So I don't think adjustment of status is dead. I think we can still do adjustment of status. It's going to take some time to get some uniform procedures from headquarters down to the local offices. In the meantime, we will continue as we have been and use the we'll add this memo into the things that we are currently looking at. The law, the current memos, all of the things. But no, short answer is I do not think that adjustment of status is dead. Teeny bit more complicated, but definitely not dead. The next thing I want to talk to y'all about this morning is the EB2 for the EB2 green card category for individuals who are from India. Every month we get what's called the visa bulletin. The visa bulletin tells us where someone stands in line, what applications they are processing for green cards. It's all done in a matrix and a chart. It's all via category. So shortly after the June bulletin was released, Department of State put out a very quick update to that bulletin, which essentially says that if you are an individual that is from India that is applying for an employment-based green card under the second preference category, they have issued all of the green cards that they are allowed to issue for this current fiscal year in your category. So what that means is that they can certainly process applications for the rest of the fiscal year, but they cannot approve any applications for the remainder of the fiscal year. They cannot approve another EB2 application for an individual from India until October 1 of this year. That is when the new fiscal year will begin. So certainly not the best news for individuals who are from India and have applied for their green card through EB2. But that is where we are right now. They did put this notice out, so I wanted to make sure that you all knew that. The next thing I have is an article that came out in The Atlantic. And The Atlantic is reporting that Department of Homeland Security is considering, they have not done, they are considering a proposal that would essentially reduce CBP staffing. So CBP are the folks in the airport. When you're flying international, you come in, you hand someone your passport, they run it through the system and they stamp your passport. Those are CBP officers. So Department of State, according to The Atlantic, is considering reducing the staffing levels of CBP officers in international airports that sit in sanctuary cities or that have sanctuary policies. So I believe New York, LA, Chicago, and DC were specifically mentioned. So we'll have to see what happens with this. If this happens, it could have really trickle-down effects. It could slow down airlines. They may have to start rerouting folks to different cities where the staffing is more robust. Flight cancellations potentially, disruption of just sort of general airport operations that surround the activities of CBP. And to be clear, CBP does a lot more in the airports than simply stamp people into the country. They do quite a bit in airports, actually. So if all of those functions are, if they're seeing reduced staffing, it could have a very serious impact on the airports in which this happens. So we will see. Again, this is not set in stone. This is not, this hasn't been decided yet, from my understanding. It was an article that came out in The Atlantic that they were considering a proposal to do this. So to the extent that we get information that this either drops off their radar screen and they decide not to do it, or they decide to do it, I will let you know. And the last thing I want to talk about this morning is H-1B season. We are still in the throes of H-1B season. We are coming to a close, but we are still in the middle of it. If you were selected in the H-1B cap for this year, your H-1B application needs to be filed by June 30th. that is my big update on H-1B CAP right now. So again, if your application was selected in the CAP for this fiscal year, then your full application needs to be filed by June 30th. That is all I have this Monday morning. Again, I'm Carol Williams with Williams Immigration. If you have any questions about CAP cases and EB2 green cards for Indian nationals or the latest adjustment of status memo, feel free to reach out. We are happy to have a chat about these things and many more as it relates to U.S. immigration. Have a great rest of your Monday and a beautiful